Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today I'd like to introduce the labor attorney's legal advice for the unfair dismissal case. A few days ago, I participated in Zoom conference. There, company asked questions about how to handle their dismissal case. So regarding this one, I found three major issues related to this dismissal. First one is whether company followed disciplinary process for termination, like written notification. Second one is how to get the settlement agreement with the dismissed employee. Third one is whether company managers behavior belong to workplace harassment or not. So these three issues are related in this dismissal case. The case is like this one. A company hired a fixed-term employee in order to replace the female employee who took child care leave for 8 months. So this new employee is supposed to work 8 months based on 3 months probation period. Then this the fixed-term employee joined May 1st, 2022. So she worked in finance team for only 3 months. During the 3 months, she selectively received the work. She is supposed to deal with all work, the process, handled but this new employee rejected. She selectively accepted the work duties. Also, she caused some dispute with some other neighboring department like IT department regarding her email or some other network service. Company was not happy with this new employee, so HR manager had a conversation with this employee. Then this new employee even complained to the HR manager why they didn't support her. So they start to argue. Then finally this the employee asked the HR manager, "You are firing, right?" So then the HR manager was so angry. Then she said yes. Then that was all. Then she didn't come to the office, and also HR manager informed her by email about her termination. So then she submitted the remedy claim to the Labor Commission. In the Labor Commission, she claimed she was harassed by manager. Also, it was unfair termination. So also she asked the financial compensation for total 8 months period she was supposed to work. So it was more than 50 million Korean won. So that is the case. Then company asked me how to handle this case. So I reviewed this case. Company fired this employee by sending email. But according to the Article 27 of the Labor Standard Act, when company fire the employee, company must issue written notification for termination. But sending email for termination is not acceptable. Only the written notification, it must contain some reason for termination and effective date, then it is valid. So company didn't follow that. So I suggest if you wait for the judgment hearing, you cannot win this case. So you have to you have to reinstate her immediately. That is the way you can reduce your additional cost. Also, company want to negotiate with the employee and dismiss the employee as soon as possible. But without reinstatement of dismissed employee, you cannot get the the settlement with her, because when she wait until the judgment hearing, company will lose the case because company neglect to issue written notification. So best way is when company intend to have some the settlement, then company must have some advantage, like a better position of settlement negotiation. That means your company should issue reinstatement order by paying the wage during the dismiss period. Then this claim for remedy claim, it will be dropped when company reinstate the dismissed employee, because the purpose of this remedy claim is designed for reinstatement. So that is why. Also, final issue is whether it belongs to workplace harassment or not. So HR manager shouted some negative word and something about this probationary or dismissed employee. Okay, whether it belongs to the workplace harassment, it depends on the definition of this workplace harassment, like using the employee's superior position, the employee some harass the employee more than the job required. So in this final interview, the HR manager shouted something negatively. That is not repeated, it's one time. So also this is the time they are talking about their about something about the work relation. So this cannot be workplace harassment. It is part of some process. That's why I mean such a one-time case of related such a abusive language, it cannot be a workplace harassment in that situation, considering all circumstances. That is how I advised. So I mentioned about 30 things about this settlement. So company must have a better position for settlement by reinstating her. Also, it cannot be a workplace harassment. This is how I advised. Okay, thank you for watching. Okay, bye bye.